You're listening to Talking Law, the podcast where business owners just like you discover how to avoid legal landmines and build value using smart legal tips.
Hi, it's Joanna Oakey here and welcome back to Talking Law, a podcast proudly brought to you by our commercial legal practice, Aspect Legal. Today we have another quick tips session. Our quick tips sessions are all about giving you the high-level areas of information that you need to know in relation to a particular area in the shortest possible time. So if you've only got 5 minutes spare and you want to know about an area of law, just flick through all of our quick tips sessions and find something that suits you. So today's quick tips session is all about how to make the unfair contracts legislation work for you if you're a small business. We talked about this legislation in episode 3 in relation to understanding the unfair contracts legislation and how it might impact your business, both in terms of if you are a supplier or if you are a customer. Today's quick tips episode is all about if you're on the receiving end of a contract which you believe to contain unfair terms and you're a small business. So if you're a small business, that means a business that has under 20 employees and you have found that you are on the receiving end of a contract that has unfair contract terms in it, you may now have rights under the unfair contracts legislation to have those clauses deemed void. Clauses that may cause significant imbalance in the rights and obligations of one party versus the other are something that the courts would be likely to deem unfair, or one that would cause detriment to the small business if it were relied on, and that isn't reasonably necessary to protect the legitimate interests of the larger business. Let's maybe look at this in the context of some examples of some types of clauses that might be considered to be unfair under this new legislation. Possible examples are clauses where, say for example, one party may have the right to vary the contract or to terminate the contract and the other party doesn't. Clauses that give one party the right to terminate for minor breaches might also be considered to be unfair. And certainly there's lots of contracts out there that have a termination clause that gives one party the right to terminate the contract on the basis of any breach in the contract. So now these types of clauses might be considered to be unfair. Other examples are where early termination fees are claimed, or where the liability of the larger party is limited or capped in a way that is unfair and unrepresentative of the relationship. Liquidated damages clauses, so those clauses that apply excessive fees in the circumstances of, say, for example, late delivery. That's an example of where liquidated damages clauses are often used in a contract. These might also now be seen to be unfair under this new legislation. And wide indemnities may now also be seen to be unfair. So in a quick recap, if you are a small business, so that means a business with a headcount of less than 20 staff, how do you determine whether or not you have the right to claim that clauses within an agreement that you have signed or agreed to are unfair and therefore void under this new legislation? Firstly, you need to establish that the contract price is less than $300,000, or if the contract is for a period of time greater than a year, that the contract value is less than $1 million. And secondly, you have to establish that this clause was part of a standard form contract. Now, a standard form contract can mean contracts that are pre-printed, so they're obviously standard form, but it might also mean contracts that aren't pre-printed, but where you did not have a genuine chance to negotiate or tailor the terms. So if you are a small business, a business with a headcount of less than 20, and you think that you have signed up to or somehow agreed to a contract that is a standard form contract under the contract price of $300,000, or if for a greater term than a year, under $1 million, and you think it contains a clause that is unfair in the circumstances, why don't you go ahead and contact us and we can have a look for you and let you know whether or not you have a likelihood of establishing an argument that that clause is void under the new legislation and therefore unenforceable. So that's it for our quick tips in relation to unfair contract terms for small businesses. If you'd like more information about this topic, head over to our website at talkinglaw.com.au. Through that website, you'll be able to download a transcript of this podcast episode if you'd like to read it in more detail. You'll also be able to find episode 3, where we talk about this concept in a lot greater detail. And there you will also find details of how to contact our lawyers at Aspect Legal. If you'd like help with any of the areas that we talked about today, or if you'd like us to help you assess whether or not you have a contract at the moment at which you are on the receiving end of an unfair contract term that you might be able to deal with under this legislation. And finally, if you enjoyed what you heard today, please pop over to iTunes and leave us a review. We'd be very grateful. Thanks for tuning in again today to the Quick Tips session on Talking Law. You've been listening to Joanna Oakey. See you next time.
Thanks for listening to Talking Law. Tune in next time for more smart legal tips and tricks to keep you clear of those legal landmines. If you want to get a download of today's show notes, head over to talkinglaw.com.au.
Are you looking for a top quality legal team to assist you in your organisation? Aspect Legal is an innovative commercial legal practice that specialises in providing fast and professional services for their clients. If you'd like to chat about how we might be able to assist you, simply head over to our website at aspectlegal.com.au to book in a time for a free discussion with one of our lawyers.